For nearly 50 years, 6 murders sat untouched in evidence lockers across the country. No suspects, no leads, no answers. Detectives retired. Families stopped expecting calls. In some towns, people stopped locking their doors again, convinced whoever did this was either dead or long gone. They were wrong. Tonight, we're looking at 6 cold cases spanning 3 decades and 4 states that all collapsed the same way, not through a confession, not through a witness finally coming forward, but through an ordinary genealogy website, the kind people use to build their family tree. Some of these cases involve a young couple who never made it home from a supply run. Others involve investigators who spent 5 years untangling one man's identity through an adoption, a name change, and a family tree that seemed to lead nowhere. But the final case tonight is the one that still unsettles the investigators who worked it. A killer who evaded detection for 17 years, unmasked only after one forensic technique failed completely, and a second one, built from nothing more than a stranger's curiosity about his own family tree, finally succeeded. These stories come from court records, police case files, and reporting from the detectives and genealogists who worked them. Let's start with the case that changed how cold cases are solved forever. A fisherman walking along a quiet stretch of Parsons Creek Road in rural Skagit County, Washington, noticed something in the brush that didn't belong there. It was November 24th, 1987. Within minutes, he had called the police. Within the hour, investigators knew they were looking at the beginning of one of the most confusing double homicides the region had ever seen. And it would take 31 years, 4 counties, and a website built for people tracing their family trees to finally answer the question that started that day. Who did this, and why? 6 days earlier, an 18-year-old named Tanya van Cuylenborg and her boyfriend, 20-year-old Jay Cook, had left their homes in Saanich, on Vancouver Island in British Columbia, for what should have been an unremarkable overnight errand. Jay's father ran a heating business, and Jay had agreed to drive down to Seattle to pick up furnace parts. Tanya, who had just graduated high school, decided to come along. They had been together about 6 months. By all accounts, they were the kind of young couple everyone assumed had their whole lives ahead of them. They took the ferry from Victoria to Port Angeles, Washington, arriving in the middle of the afternoon. From there, they drove southeast, stopping for gas along the way. A receipt later confirmed the route. That evening, they boarded a second ferry, this one from Bremerton to Seattle, purchasing tickets at 10:16 p.m. The math suggested they should have reached the city a little after 11:30 that night. What happened after they stepped off that ferry is still, in some ways, unknown. Nobody has ever definitively placed them anywhere in Seattle. They simply never called home. And in the world of 1987, before cell phones, before instant location tracking, that silence took a day or two to become alarming. Tanya's brother filed a missing persons report with Canadian police on November 19th. Families on both sides of the border began quietly hoping for the most mundane explanation. Engine trouble, a missed ferry, a detour. That hope didn't last long. Tanya's father and older brother, John, didn't wait for the phone to ring. They drove down from Vancouver Island themselves, retracing the route they believed the couple had taken, checking ferry terminals and scrap yards. anywhere Jay might have stopped to source parts for his father's business. Tanya's father even chartered a small plane to search the route from the air. It was during that search, while they were still in Washington State looking for any sign of the couple, that they got the call. A body matching Tanya's description had been found. John and his father drove to a funeral home in Mount Vernon to confirm it was her. On November 24th, Tanya's body was discovered in that wooded ditch off Parsons Creek Road, north of Mount Vernon. She had been shot in the back of the head. 2 days later, on November 26th, a bird hunter found Jay roughly 40 miles away, near Monroe, in Snohomish County. He had been beaten and strangled, his body left beneath a blanket in a wooded area beside the road. In between those two discoveries, on November 25th, the bronze 1977 Ford van the couple had been driving turned up abandoned in a parking lot in Bellingham, in Whatcom County, more than an hour north of where either body was found. A retired Bellingham police sergeant would later recall finding Tanya's identification cards discarded behind a local tavern. 4 counties, 2 bodies, 1 missing set of answers. For investigators, the geography alone made the case difficult to even conceptualize, let alone solve. Whoever was responsible had moved the victims, or forced them to travel, across a stretch of Washington state that spanned multiple jurisdictions, each with its own department, its own detectives, its own evidence room. There was no single crime scene to process. There were 4. What evidence did exist was thin. Investigators recovered a palm print from inside the van that didn't match either victim. They also recovered biological evidence, semen, found on Tanya's clothing, that could eventually be used to build a DNA profile of whoever had assaulted her. In 1987, DNA profiling as a forensic tool barely existed. It would be years before that profile could be run against anything at all. And even once DNA databases became standard practice in the 1990s and 2000s, the profile from that 1987 crime scene never matched a single person already in the system. That absence became its own kind of mystery. Whoever had killed Tanya Van Cuylenborg and Jay Cook wasn't in any criminal database. Somewhere in Washington state, or possibly nowhere near it anymore, a person carrying that DNA had never been arrested for anything serious enough to leave a genetic trace behind. Detective Jim Scharf of the Snohomish County Sheriff's Office inherited the case years later, well after the original investigators had retired without an answer. Scharf would later describe it as one of the most disturbing unsolved cases he'd ever worked, not because of any single detail, but because of how completely it seemed to resist explanation. Tips came in over the years. None of them led anywhere. Composite sketches, built from witness descriptions rather than DNA, were released to the public more than once, generating headlines and a fresh wave of calls each time, and then nothing. Investigators re-interviewed old witnesses. They chased leads that connected the case to other unsolved crimes in the region, theories that never held up under scrutiny. For 3 decades, the file grew thicker without growing any closer to a name. By 2017, 30 years after the murders, Scharf and his department made a decision that, at the time, felt more like a long shot than a breakthrough. They sent the DNA evidence to a private lab called Parabon Nanolabs, which had begun offering a service most police departments had never used before: phenotyping. Instead of comparing DNA to a database of known offenders, Parabon scientists could analyze the genetic material itself and generate a physical description and even an approximate computer-generated image of what the unknown suspect likely looked like: eye color, hair color, general facial structure. It wasn't a photograph, but it was more than anyone had ever had before. The department released the resulting composite image publicly, hoping someone would recognize it. Tips came in. None panned out. But phenotyping wasn't the only tool Parabon offered. The company also employed a genetic genealogist named C.C. Moore, who specialized in something newer and, at the time, almost entirely untested in a criminal court: upload unidentified crime scene DNA to a public genealogy website and using the family trees of distant, unknowing relatives to work backward toward a name. In the spring of 2018, Moore logged into GE Deadmatch, a site built for hobbyists tracing their ancestry, not for police work. Among roughly 1 million DNA profiles in the database, the unidentified genetic material from the 1987 crime scene matched, distantly, to 2 people. Neither of them was a suspect. Neither of them had any idea their DNA was about to help crack a 3-decade-old double murder. They were simply people who had spit into a tube because they wanted to know where their ancestors came from. Moore began building family trees outward from those 2 distant matches, looking for the branch where the 2 trees would eventually intersect. It's slow, meticulous work, cross-referencing birth records, marriage records, obituaries, trying to find the living relative who sits at the center of both trees. In this case, according to Moore's own account, it took roughly 2 hours to arrive at a name: William Earl Talbot II, a truck driver living in SeaTac, Washington, who at the time of the murders had been in his 20s and living not far from where the crimes occurred. 2 hours, after 31 years. But a name from a genealogy match isn't evidence, it's a lead. Investigators still needed Talbot's actual DNA to compare against the crime scene sample, and they needed to get it without alerting him that he was a suspect. Detectives began quietly following the SeaTac truck driver, waiting for an opportunity that wouldn't require a warrant. Discarded property left in public is fair game for testing. In early May 2018, while Talbot was driving in South Seattle, a paper cup fell from his truck. An undercover officer moved in and collected it before he could notice. The saliva on that cup came back as a match to the DNA from the 1987 crime scene. Detectives later obtained a formal cheek swab from Talbot directly. It matched again. On May 18, 2018, William Talbot was arrested and charged with the murder of Tanya van Cuylenborg. A second charge, for the murder of Jay Cook, followed shortly after. Prosecutors described the killings in blunt terms in their court filings. Jay had been beaten and strangled. Tanya had been shot. Snohomish County prosecutor Craig Matheson wrote that the violence appeared to be as random as it was savage, meaning, as far as anyone could determine, Talbot had not known either victim before that night. There was no relationship, no motive rooted in any prior connection. 2 young people on a supply run for a family business had apparently crossed paths with a stranger, and neither of them made it home. The case that followed was historic, for reasons that had nothing to do with the crime itself. This was the first time in the world that a person identified through investigative genetic genealogy would stand trial in front of a jury, with prosecutors asking that jury to convict based partly on a method that had never been tested in an American courtroom. The defense did not challenge the science of genetic genealogy itself. That question, whether it was fair or reliable to build a case using DNA uploaded by unsuspecting distant relatives, remained a subject of public debate, but it was not what the trial turned on. For a week and a half, jurors heard from the people who had touched this case at every stage across 31 years. Retired officers described processing the van and the crime scenes in 1987. A deli clerk who had served the couple food on their trip testified that she remembered Tanya's face because it looked like she'd been sleeping in the van, and remembered Jay as the only customer who ever tried to pay for the gas himself. The bird hunter who found Jay's body described the wet, leaf-covered ground that had made the search so difficult. Detective Scharf, the man who had carried the case for years, fought back tears on the stand, describing the phone call in which Parabon told him they had a name. The defense argued that Talbot had lived what his own attorney called a quiet, unremarkable life, and pointed to the absence of any other physical evidence tying him to the level of violence prosecutors described. Talbot's lawyers noted he had never been known to own a firearm or smoke cigarettes, and highlighted an unidentified second DNA profile recovered from the case that didn't belong to Tanya or to Talbot, arguing it suggested someone else may have been present. Prosecutors countered that Talbot's own DNA on Tanya's body and his palm print inside the van were enough, regardless of who else may have been nearby. After a week and a half of testimony and 3 days of deliberation, a Snohomish County jury convicted William Talbot on 2 counts of aggravated first-degree murder in June 2019. Judge Linda Creasy sentenced him to life in prison without the possibility of parole the following month, the only sentence state law allowed for the charges. In the courtroom, Detective Scharf embraced Jay Cook's mother, Lee, after 3 decades of working toward that single moment. For the Van Cuylenborg and Cook families, 31 years of not knowing appeared, finally, to be over. It wasn't quite that simple. In December 2021, a Washington State Court of Appeals overturned Talbot's conviction entirely, on grounds that had nothing to do with the DNA evidence or the genealogy that led to his arrest. The court found that one juror, a woman who had disclosed during jury selection that her mother had survived domestic violence, and that she wasn't certain she could remain impartial given the nature of the evidence, should never have been seated. The appellate judges ruled that her expressed doubts amounted to actual bias, and that seating her had denied Talbot a fair trial. Prosecutors were, in their own words, devastated, and immediately began preparing either to appeal further or to retry the entire case from scratch. They appealed. In December 2022, the Washington State Supreme Court took up the question and, unanimously, reinstated the guilty verdicts. The justices found that while the juror had expressed uncertainty, Talbot's own defense attorneys had peremptory challenges available, meaning they could have removed her from the jury without needing to give a reason, and simply chose not to use one. The High Court ruled that this choice undercut the claim that her presence had made the trial unfair. The Washington Supreme Court's ruling was unanimous. The justices reasoned that Talbot's own defense attorneys had 3 peremptory challenges available during jury selection, meaning they could have dismissed the juror in question without ever needing to explain why, and simply hadn't used one. That single procedural choice, made in a matter of seconds during jury selection, ultimately outweighed the jurors' own stated doubts about her impartiality. As of the most recent reporting on the case, Talbot remains in custody at the Washington State Penitentiary, with further appeals still possible under the standards courts use to evaluate new forensic techniques, including the reliability of genetic genealogy itself under the legal tests used to admit scientific evidence. So far, that underlying science has never been the basis of a successful appeal. What nearly overturned the case permanently was something far more ordinary: a single juror's answer during jury selection, decades after the crime itself, and a defense decision about whether to challenge her. Tanya's brother, John Van Cuylenborg, would later describe the years of appeals as reopening a wound the family believed had finally closed. For families in cases like this one, a conviction rarely feels like the end. It feels like the next chapter of a much longer wait. What the case did leave behind, regardless of its ongoing legal path, was a template. Before 2018, genetic genealogy was a hobbyist's tool for building family trees, used by amateur researchers tracing ancestry and long-lost cousins. After the Talbot case, it became one of the most significant developments in cold case investigation in decades, adopted by departments across the country almost overnight. The technique's success also raised its own questions about privacy, about consent, about whether the distant relatives who upload their DNA for genealogy purposes should have any say in how it's later used by police. Partly in response to cases like this one, GEDmatch itself changed its policies within a year, requiring users to explicitly opt in before their genetic data could be searched by law enforcement at all. Detective Scharf, the man who inherited an unsolvable file and refused to let it stay that way, had helped prove that a public ancestry website, built for people curious about where their great-grandparents came from, could also be the thing that finally answers who killed two strangers on a rural Washington road. The Talbot case was the one that proved the method could work in front of a jury. But it wasn't the first time genetic genealogy quietly pointed detectives toward a name that same year. In a small Arkansas town, investigators had already begun asking the same question months earlier about a case that had haunted them even longer: a young store clerk who vanished during a routine closing shift, and a killer who had spent nearly 3 decades believing he was the only one who would ever know what happened to her. If that Washington case proved investigative genetic genealogy could survive a jury trial, the case that follows proves something else. Sometimes the answer arrives on time, but the person who deserves to face it doesn't. Her cigarette was still burning in the ashtray. Her coffee was still steaming in the cup. That's what Pam Felkins' husband found when he walked into the Crossroads video store in Greenbrier, Arkansas, on the evening of February 2nd, 1990, looking for his wife. She wasn't there. Nothing seemed disturbed. He assumed at first that she'd stepped into the bathroom. She hadn't. Pam Felkins, 32 years old, just over 5 feet tall and less than 100 pounds, was gone. Her body was found the next morning, dumped along Clinton Mountain Road, several miles from the store. She had been raped, stabbed, and beaten. Word spread through Greenbrier fast, the way it does in a small town, and within days, Searchers and volunteers had combed the wooded area around the dump site, looking for anything investigators might have missed. A weapon, a piece of clothing, anything. Nothing turned up. For the next 28 years, the only thing anyone knew for certain about her killer was a single piece of biological evidence recovered during her autopsy, DNA that matched no one in any law enforcement database, anywhere. Who takes a woman from behind a store counter on an ordinary Friday night? And why has no trace of him ever surfaced anywhere since? Not in a courthouse, not in a database, not in the memory of anyone who thought they knew him. Greenbrier in 1990 was a small town, the kind where people assumed they knew their neighbors, and where a crime like this one didn't fit anything the community had ever experienced. Investigators with the Faulkner County Sheriff's Office had almost nothing to work with. There was no forced entry to explain, no witnesses who saw a struggle, no physical description beyond a vague memory. A couple leaving the video store that evening recalled passing a man on his way in, someone with what looked like a surgical scar on his forearm. It was the kind of detail that meant everything and nothing at the same time, useless without a face to attach it to. For years, the case moved the way most cold cases move, which is to say, it barely moved at all. Investigators tested DNA against numerous persons of interest in the sheriff's own later description and came up empty every time. Pam Felkins' name stayed local. Her file stayed open. Her family kept living in a town that had never given them an answer. By 2018, 28 years after Pam's murder, Sheriff Tim Riles made a decision that mirrored what departments around the country were quietly beginning to try. In March of that year, his office announced they were resubmitting the case's original evidence, the DNA, the toxicology samples, the trace evidence, to the Arkansas State Crime Lab for a fresh look, using methods that hadn't existed in 1990. Investigators Folks and Hill, the two detectives now carrying the file, brought in Parabon Nanolabs, the same Virginia-based company that would go on to help crack the Van Cuylenborg and Cook case in Washington state that same year. Parabon's scientists started with phenotyping, the same technique Snohomish County had tried first, before ever attempting genealogy. From the crime scene DNA, they built a computer-generated composite, a prediction of the killer's likely eye color, hair color, and facial structure. The same broad categories of detail Parabon would later generate for the unknown suspect in the Van Cuylenborg and Cook case. The sheriff's office released the image publicly in March 2018, hoping someone in the community would recognize a face they'd known for almost 30 years. Nobody came forward. The composite, on its own, wasn't enough. So investigators moved to the same next step that was quietly transforming cold case units across the country that year, uploading the unidentified DNA to a public genealogy database and building outward through the family trees of people who had no idea their DNA was about to be used this way. A genetic genealogist began the same painstaking process C.C. Moore would later use in Washington state, working from a handful of distant matches, cross-referencing marriage records, census data, and public family trees, narrowing branch by branch until only one living descendant fit every piece of the puzzle, a man born in Arkansas in 1958, who had, at various points, lived within a short drive of both the video store and the dump site where Pam's body was found. It worked. By October 2018, genetic genealogists had built a family tree that led to a name: Edward Keith Renegar. At a press conference that October, Faulkner County Sheriff Tim Riles told reporters the match was 99.99% certain. To confirm it beyond any doubt, investigators located and tested DNA from Renegar's own biological daughter. It matched at the same 99.99% confidence level. Renegar had lived in Greenbrier at the time of Pam Felkins' murder. He'd worked at a manufacturing company in nearby Conway from the late 1970s into the early 1990s, and according to investigators, he had been a frequent customer at the very crossroads video location where Pam worked. He wasn't a stranger passing through town. He was, in the plainest sense, a regular. And he wasn't unknown to the justice system either. In 1994, 4 years after Pam's murder, Renegar was convicted of a strikingly similar crime: kidnapping a woman at knife point in nearby Cuylenborg County. According to investigators, he approached a small-framed young woman, forced her into a vehicle at knife point, and bound her with rope. The same basic pattern investigators believe he may have used on Pam Felkins 4 years earlier. That victim managed to escape before he could finish whatever he intended. Renegar was caught, tried, and convicted, but the sentence handed down for a knife-point kidnapping and binding was just 10 months in an Arkansas prison, a sentence that, in hindsight, looks almost unthinkably short given what investigators now believe he'd already done once before. No one investigating that 1994 case appears to have connected it to the unsolved Felkins murder 4 years earlier, even though the methods, binding a victim, targeting a woman of similar size, happened less than an hour from where Pam had disappeared. It's the kind of missed connection that, in hindsight, feels almost impossible to overlook. 2 crimes with the same signature, separated by only a short drive and 4 years, handled by different investigators who had no reason at the time to think they might be looking at the same man. After his release in 1995, Renegar left Arkansas and moved to Utah, where he lived with his father for the remainder of his life. His own daughter would later tell investigators that he had been abusive toward both of his ex-wives, and that one had taken out a restraining order against him. Beyond those fragments, gathered second-hand from relatives after his death, investigators found strikingly little. He left no diary, no confession, no correspondence that referenced Arkansas or the crime at all. Whatever happened in Greenbrier on the night of February 2nd, 1990, Renegar apparently carried with him quietly for the rest of his life. Through a decade working as a truck driver, through 2 marriages, through a move across 3 states, without ever once surfacing as a suspect in anyone's investigation. The Arkansas Department of Corrections confirmed one more detail that investigators found hard to look past. Renegar had a surgical scar on his left forearm, in the same place where witnesses, decades earlier, recalled seeing a mark on the man they passed outside the video store. It was, by any measure, an overwhelming case. Prior violence against women, a documented pattern, a physical detail that matched a decades-old witness memory, a DNA match confirmed twice, once directly and once through his own child. There would be no trial. Edward Keith Renegar had died of natural causes in Salt Lake City on September 5, 2002, 16 years before investigators ever learned his name. He had lived the last years of his life entirely undetected, not as a fugitive hiding from anyone, simply as a man. Nobody had connected to anything. He was never questioned about Pam Felkins. He was never a suspect while he was alive. As far as the public record shows, he never spent another day answering for what happened in Greenbrier. Sheriff Riles, standing in front of Pam Felkins' friends and family at that 2018 press conference, chose his words carefully. He called Renegar the case's primary suspect, not its confirmed killer, and explained that investigators still hoped to develop corroborating physical evidence, something that had once belonged to Pam, a weapon, anything that might let them close the file with complete certainty rather than a genealogical match alone. He also raised a question that has never been fully answered, whether Renegar acted alone that night, or whether someone else was ever involved. Investigator Kent Hill, one of the two detectives who had carried the file for years by that point, told reporters he couldn't comment on whether they suspected an accomplice, only that the door on that question remained open. It's a detail easy to overlook in a case that otherwise reads like a closed loop. DNA in, name out. But it means that even with a 99.99% genetic match on record, Faulkner County has never been willing to declare with total confidence that they understand everything that happened that February night. "We will never stop until we put this thing to rest," Riles told the families gathered that day. "We will never quit. I promise you that." For Pam Felkins' family, the moment was strange in a way that few true crime cases prepare you for. There was no arrest, no arraignment, no trial date to circle on a calendar, no chance to watch the person who did this explain himself, or refuse to. 28 years of not knowing ended not with justice in the traditional sense, but with a name, a date of death, and a quiet, permanent absence of anyone left to hold accountable. For nearly 3 decades, Pam Felkins existed publicly, mostly as a case number and a composite sketch, a name attached to an unsolved file rather than a life. The people who loved her had spent that time carrying a version of her that had nothing to do with how she died. A wife, a co-worker, someone who closed up a small video store on a Friday night, the way she probably had dozens of times before. The genealogy match didn't just answer who killed her. For her family, it was the first time in 28 years that the story about Pam could stop being only about the unanswered question and start being about her again. It's worth sitting with what that means. So much of what makes these stories satisfying to follow is the shape of resolution, the arrest, the courtroom, the verdict. Pam Felkins' case never gets that shape. Her killer was identified with more certainty than almost anyone else on this list. Tested twice, matched twice, confirmed by his own daughter's DNA, and none of it produced a single day in a courtroom. The case remains, technically, open. Investigators have said they aren't ready to close it, not because they doubt who did it, but because doubt was never really the obstacle. Consequence was, when Sheriff Riles held his press conference in October 2018, Pam Felkins' family sat in the front row alongside 2 former sheriffs, the Greenbrier police chief, prosecutors, and investigators from the state crime lab, a room full of officials who had spent years, in some cases entire careers, trying to close this one file. Riles told reporters that despite everything the DNA had confirmed, he still didn't feel comfortable calling Renegar's identity a closed case. What he wanted next, he said, was simply to understand who the man actually was. Investigators knew what his DNA proved. They knew almost nothing else. Nobody seems to really have a lot of insight into him, outside of family, Riles said. His personal life outside of family is what we're looking for. That gap is its own kind of unsettling detail. Renegar had, by all accounts, been an entirely unremarkable presence in Greenbrier, 6 feet 4 inches tall, born in 1958. He drove through town in a rotation of different vehicles over the years. A red pickup truck, a yellow one, a small grey car, a sedan, according to records investigators later compiled. Pam's own family and friends told reporters they knew of no connection between her and Renegar at all. He wasn't a stranger to the video store. He was a regular there, someone who had likely stood at that counter and spoken to Pam more times than anyone could now count. And yet nobody who knew her ever thought to mention his name, because there was nothing about him that stood out enough to remember. That's the detail that makes this case different from most. It isn't a story about a killer who vanished without a trace, or one who evaded capture through cunning. Edward Renegar didn't need to evade anything. He simply wasn't memorable enough to be suspected, right up until a DNA sample matched his daughter's genetic code with 99.99% certainty 16 years after he was already gone. Pam Felkins' case wasn't an isolated outcome either. Among the roughly 24 genetic genealogy identifications made across the country in 2018 alone, several ended the same way. Investigators found a confirmed name, closed the biological question entirely, and discovered the person they were looking for had already died, sometimes decades earlier, of causes that had nothing to do with the crime at all. Researchers tracking the technique's early cases would later mark those files differently from the ones that led to trial, a quiet acknowledgement that identification and justice, however closely they sound alike, aren't always the same outcome. It's one of the stranger consequences of a technology built to answer the question of who. It was never built to answer the separate question of what happens once you know, and the person responsible is already beyond anyone's reach. Cases like this one raise a question that genetic genealogy, for all its power, can't fully answer. What does justice look like when the truth arrives decades too late for the system built to deliver it? For families in that position, the answer has to be found somewhere other than a courtroom, in simply knowing, finally, after almost 3 decades of not. Faulkner County wasn't the only small department to learn that lesson in 2018. A few states east, in the hill country along the Tennessee and Georgia border, investigators were working through a family tree of their own that fall, and what it eventually revealed made the Felkins case look almost contained by comparison. Where Pam Felkins' file involved 1 victim and 1 suspect, the case waiting in Greenville, South Carolina, and the towns around it would turn out to involve a string of murders across 2, and eventually more, states, and a man some investigators now believe may be one of the most prolific unidentified killers in American history. He too had been hiding in plain sight, under a name nobody had ever connected to anything, until the same technology that named Edward Renegar connected all of it at once. A detective would later say it plainly. The reason this case finally broke wasn't a mistake the killer made. It was a 13-year-old girl who fought back. Investigators recovered DNA from underneath Amy Ayres' fingernails at the scene of one of the most notorious unsolved murders in Texas history. For more than 3 decades, that DNA sat in evidence storage, waiting for technology to catch up to what it could prove. When it finally did, it didn't just identify a killer who had died years before anyone learned his name. It also meant that 4 innocent men, who had already spent years living under suspicion, arrest, and in 2 cases prison, could finally be told, officially, in a courtroom, that they had never done anything wrong at all. On the night of December 6, 1991, 4 teenage girls closing an "I can't believe it's" yogurt shop on West Anderson Lane in Austin, Texas, were bound, gagged, and shot in the head. Whoever did it then set the store on fire, destroying much of the physical evidence before anyone discovered what had happened. Eliza Thomas was 17. Jennifer Harbison was 17. Her younger sister Sarah was 15. Amy Ayers was 13. The murders became known simply as the yogurt shop murders, and for the city of Austin, they became a wound that never fully closed. Investigators chased thousands of leads over the following years. The case drew national attention almost immediately, and with that attention came an unusual problem. Multiple people confessed to the crime over the years that followed, confessions that investigators eventually had to rule out one by one as details failed to match the evidence. It's a pattern that shows up more often than people expect in high-profile unsolved cases. False confessions driven by any number of motives: attention, guilt over unrelated things, genuine confusion, and each one had to be run down and eliminated before investigators could move forward. It wasn't until 1999, 8 years after the murders, that 4 young men, all of whom had been teenagers themselves at the time of the killings, were arrested and charged with capital murder. 2 of them, Robert Springsteen and Michael Scott, went to trial. There was, according to the detective who would later reopen the case, no physical evidence connecting either of them to the crime scene. What prosecutors had instead were confessions, statements each man gave to police that implicated himself and the other 3. Springsteen and Scott were convicted largely on those statements. Scott received life without parole. Springsteen was sentenced to death. The other 2 men charged, Maurice Pierce and Forrest Wellborn, never stood trial. Wellborn's case was dismissed after 2 separate grand juries refused to indict him. The charges against Pierce were eventually dropped as well, after he'd already spent 3 years in jail awaiting a trial that never came. All 4 men had been ordinary teenagers in Austin at the time of the murders. None of them would live an ordinary life again. Even the 2 who were never convicted of anything spent years afterward known publicly as suspects in one of the state's most notorious crimes, a reputation that followed them regardless of what a courtroom had or hadn't decided. Maurice Pierce would never see any of this happen. In 2010, an Austin police officer pulled him over for running a stop sign. Pierce fled on foot, and when the officer caught him, a struggle followed. Pierce grabbed the officer's knife. The officer shot and killed him. Pierce had spent the 11 years since his charges were dropped, never formally cleared, living under a cloud of suspicion the justice system had created and then simply walked away from, and he died, still carrying it, 7 years before genetic genealogy would even identify Robert Brashers, and 16 years before Austin would finally say, out loud, that Pierce had never done anything wrong. For the 3 men still living, the wait continued. Then, in the mid-2000s, both convictions were thrown out. The Texas Court of Criminal Appeals found that the trials had violated the men's constitutional right to confront their accusers, since each man's confession had been used against the other without either being able to cross-examine it directly. Prosecutors wanted to retry Springsteen and Scott, but new DNA testing, using methods that hadn't existed at the time of the original trials, was run on evidence from the crime scene in 2008 and 2009. It revealed a complete male genetic profile that didn't match Springsteen, didn't match Scott, and didn't match either of the other two men who had once been charged. A judge ordered the remaining charges dismissed in 2009, which meant, as of that year, Austin had an unidentified male DNA profile sitting at the center of one of its most devastating unsolved cases, and 4 men who had spent a decade being publicly regarded, in the eyes of much of the city, as the killers of 4 teenage girls, despite the fact that the evidence had never actually supported that conclusion. The case went cold again. It stayed that way for over a decade, through documentaries, tips, renewed public interest, none of it producing an answer. While Austin's case sat unsolved, a very different DNA profile was quietly working its way through cold case labs, almost 1,000 miles away. In April 1990, more than a year and a half before the yogurt shop murders, 28-year-old Genevieve Zitricki failed to report for work in Greenville, South Carolina. She was found dead inside her apartment, beaten and strangled in her bathtub. Her case, like so many others on this list, went unsolved for years. Its only real lead, a DNA profile, with no match anywhere. In 2006, advances in forensic testing let Missouri investigators resubmit evidence from an entirely separate case, the 1998 murders of Sherry Scherer, 38, and her 12-year-old daughter Megan, who had been shot to death inside their home near Portageville, Missouri. Megan had also been sexually assaulted. That same year, hours after the Scherer murders, a man had tried to force his way into a home in nearby Dyersburg, Tennessee, shooting a young mother who refused to let him inside. She survived and gave police a description. The new DNA profile developed from the Scherer case matched CODIS, the National Criminal Database, to the unsolved Zitricki murder in South Carolina. Investigators from 3 states began working the connected cases together, running down more than 1,200 leads and featuring the still unidentified suspect on America's Most Wanted. Still, no name emerged. In 2017, that same profile matched once more, this time to the unsolved 1997 rape of a 14-year-old girl in Memphis, Tennessee. 4 states, 3 decades, 1 unidentified man responsible for all of it, and still no name. In 2018, investigators finally turned to Parabon Nanolabs and genetic genealogist C.C. Moore, the same team that would go on to help crack the Van Cuylenborg and Cook case in Washington state that same year. Moore built a family tree outward from the crime scene DNA, working through distant genetic matches until the branches converged on one man, Robert Eugene Brashers. To confirm it, investigators exhumed Brashers' remains from a cemetery in Paragould, Arkansas, in September 2018. Laboratory testing extracted from his bones conclusively matched the DNA from the Zitricki murder, the Scherer murders, and the Memphis rape. There was, at last, a name. There was also a problem. Robert Brashers had been dead since 1999. At a news conference announcing the match, New Madrid County, Missouri, Sheriff Teree Stevens didn't mince words. "He is a serial rapist and a serial killer," Stevens told reporters, but no more. For the Scherer and Zitricki families, who had waited decades without so much as a name to attach to their grief, the announcement finally answered the one question that had defined their lives since the 1990s. It didn't undo what had happened. It simply meant the not knowing was over. Brashers had been born in Newport News, Virginia, in 1958, the youngest of 4 children. His adult life reads like a long, mostly unnoticed trail of violence across state lines. In 1986, he was convicted of attempted second-degree murder in Florida after shooting a woman the year before, and served roughly 3.5 years of a 12-year sentence before being paroled. He used a rotating set of aliases built from his own family members' names. He drove a series of stolen vehicles across multiple states, evading serious suspicion for over a decade, despite a criminal history that, in hindsight, reads as an obvious escalating pattern. His life ended on January 13th, 1999, when police in Kennett, Missouri, traced a stolen license plate to a Super 8 motel and found Brashers hiding in a room with his wife, daughter, and 2 stepdaughters. After a 4-hour standoff, he let his family go, then shot himself. He died from his injuries 6 days later, on January 19th. At the time, the officers who responded had no idea they were watching one of the country's most violent unidentified offenders end his own life over a stolen license plate. He would remain unidentified as anything more than a man with a long record for another 19 years. For a while, that seemed to be where the story ended. A serial killer named nearly 2 decades after his death, 3 solved cases in 3 states, a measure of closure for the Zitricki, Scherer, and Memphis families that Pam Felkins' family in Arkansas never fully received. It wasn't where the story ended. In 2022, Austin cold case detective Daniel Jackson reopened the yogurt shop file. He had inherited a case that already carried enormous weight. 4 dead teenagers, 4 wrongly accused men, 1 confirmed unidentified male DNA profile from the crime scene, sitting unmatched since 2009. Jackson began working through old physical evidence with newer forensic tools, including the National Integrated Ballistic Information Network, a database that compares markings left by firearms. In June 2025, Jackson ran a .380 caliber shell casing, recovered years earlier from a drain inside the burned yogurt shop, through that ballistics database. It matched a 1998 case in Kentucky. Separately, the unidentified male Y. Sturden profile from the yogurt shop crime scene, developed years earlier but never matched to anyone, was manually compared against profiles from other unsolved cases across the country. In August 2025, South Carolina's State Crime Lab reported a complete match between their own database profile, the one that had identified Robert Brashers back in 2018, and Austin's unidentified yogurt shop profile. The gun mattered as much as the DNA. The taut .380 pistol Brashers used to kill himself in 1999 was the same caliber and model used to kill Amy Ayers in 1991. Investigators also turned up an old detail that had been sitting in police records the entire time. 2 days after the yogurt shop murders, Brashers had been stopped and detained at a border checkpoint near El Paso, driving a truck stolen out of Georgia on his way he apparently told officers, to visit his father in Arizona. He was arrested that day for auto theft and for being a felon in possession of a firearm. The gun taken from him was eventually returned to his father, who investigators believe may have given it back to him. It was the same gun ballistics tests would later show that Brashers used to end his own life 8 years later in Missouri. On September 29, 2025, the Austin Police Department announced what its detectives had confirmed. Robert Eugene Brashers, already linked to murders in South Carolina and Missouri and a rape in Tennessee, had also killed Eliza Thomas, Jennifer Harbison, Sarah Harbison, and Amy Ayers in Austin in 1991. Detective Jackson credited the break, ultimately, to Amy herself. It was the DNA she'd left behind while fighting her attacker that gave investigators the profile that, 34 years later, finally closed the loop. The announcement did more than name a killer. It also meant Austin now had to reckon, formally, with what it had done to 4 innocent men. In February 2026, Travis County prosecutors brought Michael Scott, Robert Springsteen, and Forrest Wellborn before a judge. Maurice Pierce, of course, could not attend. State District Judge Dana Blasey told the 3 surviving men, in open court, that they were innocent, calling the declaration an obligation to both the rule of law and the dignity of the individual. Prosecutors did not soften the moment. Over 25 years ago, the state prosecuted 4 innocent men, one told the court, for one of the worst crimes Austin has ever seen. We could not have been more wrong. Springsteen, who had once sat on death row for a crime he did not commit, did not attend the hearing. In a statement read on his behalf, he described 10 of his 27 years since arrest spent in solitary confinement, 1 hour a day outside his cell, followed by years of what he called persecution and harassment after his release. Maurice Pierce's daughter, Marissa, addressed her father directly in the courtroom. "Daddy, you have your name back," she said. "The world knows what you were trying to say all along." In May 2026, the city of Austin agreed to a $35 million settlement to be divided among the men and their families, closing what the city manager called the final chapter of the case. It's worth pausing on what actually happened here, because it's easy, in a story this large, to focus only on Brashers, the serial killer whose crimes stretched across 6 states and at least 8 known murders over less than a decade. But the more unusual outcome of this case isn't that a killer was finally identified after his own death. It's that identifying him also proved, conclusively and far too late for one of them, that 4 other men had spent decades paying for a crime none of them committed. Genetic genealogy is usually a story about naming the guilty. In Austin, it turned out to be just as powerful a tool for naming the innocent. Austin criminal defense attorney Sam Bassett, reflecting on the exoneration hearing, called a formal declaration of innocence extremely rare, something granted to only a small fraction of people who are wrongly convicted in the first place. Most exonerations end with charges simply dropped, or a conviction quietly vacated, a legal shrug that leaves the underlying suspicion hanging in the air indefinitely. What Scott, Springsteen, and Wellborn received was different. A judge, in open court, stating outright that they had done nothing wrong. It came after 27 years, after a death sentence, after solitary confinement, after a father who never got to hear it. But it came, and for a case that once seemed destined to remain a permanent Austin tragedy without an ending, that's no small thing. Robert Brashers connected 4 states and at least 3 decades of violence under one unrecognized name. But even a case this vast started the same way every case on this list did, with a DNA sample that meant nothing, sitting in an evidence room until the right technology and the right detective finally looked at it again. The next case took 47 years to reach that same moment, and when it finally did, investigators discovered something almost impossible to process. The man they'd been searching for the entire time had been living 17 minutes from the crime scene since before most of the original detectives had even retired. The jury never knew the man they were deciding on was already dead. For 2 weeks, 12 jurors in Everett, Washington, had listened to testimony about a murder that happened before most of them were born. On a Friday afternoon in November 2020, they began deliberating. They went home for the weekend still undecided. On Monday morning, before they returned to finish their work, the defendant took his own life at a house 5 miles from where his victim's body had been found 48 years earlier. Nobody told the jury. That afternoon, they reached a verdict anyway. Guilty. The case had taken longer to solve than almost any other in the county's history, and it had ended in a way no one in that courtroom had ever seen before. On August 23, 1972, 20-year-old Jody Loomis climbed onto a white 10-speed bicycle outside her home in what's now Mill Creek, Washington, and rode toward a stable roughly 3.5 miles away, where she kept a horse named Saudi. She was last seen crossing the highway around 5 o'clock that evening. About 30 minutes later, 2 people walking through a wooded area near what's now 164th Street Southwest found her, shot in the head with a .22 caliber bullet. She died on the way to the hospital. Jody had been sexually assaulted. She was found wearing only socks and a pair of hiking boots. Boots that, investigators would later learn, she'd actually borrowed that day from her 12-year-old sister. Her family was shattered instantly and permanently. Her sister, Jana, would later describe the night a detective knocked on their door. Their mother collapsed at the news. Their father didn't even have time to catch her. For decades, the case produced almost nothing. Investigators in the early 1970s lacked the forensic tools to test the biological evidence collected at the scene in any meaningful way. The file went cold, then colder. In 2008, the Snohomish County Sheriff's Office Cold Case Unit, trying to generate fresh public interest, printed a deck of playing cards featuring unsolved local homicides handed out inside Washington state prisons in hopes that someone, somewhere, might recognize a name and talk. Jody Loomis appeared on the 10 of hearts, a photo of her in riding gear beside her horse, another close-up showing her face behind large, round tinted glasses. Even then, 11 years before an arrest, hers was already the oldest case in the deck. That same year, a state crime lab technician re-examining the physical evidence made a discovery that had gone unnoticed by every investigator who'd touched the file before him. A small semen stain preserved on one of the boots Jody had been wearing, evidently deposited by her killer. It was enough to build a partial DNA profile. Detectives ran it against the National Criminal Database. Nothing matched. Whoever had done this had never been arrested for anything serious enough to leave his DNA on file anywhere. For another 10 years, The profile sat there, correct, complete, and useless, waiting for the rest of the world to catch up to it. Through all of it, the case never fully left public memory. A sheriff's office cold case volunteer named Chuck Wright carried details of Jody's file with him for years, still hoping a fresh tip might eventually surface. It was the kind of quiet, unglamorous persistence that keeps decades-old cases alive long enough for new technology to eventually catch up to them. In July 2018, Snohomish County investigators sent that decade-old profile to Parabon Nanolabs, the same company that same year, was helping crack the Van Cuylenborg and Cook case for the same sheriff's office, and the Golden State Killer case in California. An Oregon-based genetic genealogist named Deb Stone took the profile and began building outward, the same slow, painstaking process used in every case like it. Distant genetic matches, public family trees, marriage records, obituaries, looking for the branch where all the threads converged. The trail led to an Edmonds family with 7 siblings. Stone determined the suspect had to be one of 6 sons. Investigators zeroed in on one, Terrence Miller, a retired heavy equipment operator who, along with his wife of over 40 years, ran a small ceramics business called Miller's Cove out of their garage. By the fall of 2018, detectives had already quietly identified Miller as their suspect, though they weren't ready to move yet. At one point, investigators paid a visit to the Edmonds house, where Miller and his wife sold their pottery, posing as customers. His wife invited them inside. On a table sat a single copy of the local newspaper, the Daily Herald, nearly 7 months old by then. Its front-page story, about an unrelated cold case, described how new DNA technology had just helped the same sheriff's office arrest a truck driver for a decades-old rape and double homicide. A story that, as it turned out, was about William Talbot and the Van Cuylenborg and Cook murders. Neither Miller nor his wife gave any indication they understood what that story might soon mean for them. Here's what made the case almost impossible to process once it broke. Terrence Miller hadn't fled. He hadn't left the state, changed his name, or vanished into obscurity. He had spent nearly every day of the previous 46 years living within a few miles of the wooded lot where Jody Loomis's body was found, working construction jobs across western Washington, marrying and divorcing and remarrying, raising a family, and eventually opening a small pottery shop that he and his wife ran out of their own garage on weekends, selling ceramics to neighbors who had no idea what they were driving past every time they turned onto his street. Investigators quietly built their case before making an approach. In August 2018, undercover officers followed Miller to the Tulalip Casino and watched him throw away a used coffee cup. They retrieved it. The Washington State Patrol Crime Lab extracted a DNA profile from the cup. In September 2018, it came back as a match to the semen recovered from Jody Loomis's boot decades earlier. Investigators didn't move immediately. They spent months quietly tracking Miller's movements, building the strongest possible case before ever approaching him. Detectives also started piecing together his history. Court records would later show he'd been accused of sex crimes on at least 5 separate occasions since the 1960s, none of which had ever resulted in a serious conviction. He had married his first wife when he was 18 and she was 14. They divorced 2 years later. His second wife gave birth to a daughter 8 months after that divorce. He married a third woman in 1967. Throughout the months detectives spent quietly watching him, Miller remained active on Facebook, posting about his decades of work on heavy equipment across western Washington from 1958 to 1995, entirely unaware that the same detail helped confirm investigators had the right family. Nothing in his public record had ever connected him to a murder in Snohomish County or anywhere else. On April 10, 2019, deputies arrested Terence Miller at his home. He was charged with first-degree premeditated murder and held on $1 million bail. He declined to speak to investigators about the case. Detectives, still trying to close every gap in a 47-year-old file, publicly asked anyone who'd known Miller in the early 1970s to come forward, along with anything he might have said about the vehicles he drove, where he'd worked, or a missing detail that had nagged at the case since 1972. Jody's bridal, never recovered, never explained. Miller posted bond and was released to await trial under electronic home monitoring. A year earlier, as attorneys had debated how high his bail should be set, prosecutors had argued that Miller was effectively facing a life sentence if convicted, the kind of stakes that give a defendant reason to consider fleeing, or worse. That argument would look prescient by the time the trial ended. His trial began in October 2020, more than a year and a half after his arrest, and 48 years after the murder itself. For 2 weeks, prosecutors and defense attorneys argued over what the DNA evidence actually proved. Testimony came from people who had known Jody or seen her on the day she died, alongside the forensic experts who explained how a single stain, invisible for 36 years, had finally been isolated, sequenced, and matched. Prosecutors Craig Matheson and Bob Langbane pointed repeatedly to the semen recovered from a boot Jody had borrowed from her 12-year-old sister that morning, evidence that had sat undetected for over 3 decades before a lab technician finally found it. The defense, led by attorney Laura Martin, argued the DNA alone didn't prove murder, and that evidence mishandled and degraded across nearly 5 decades couldn't be trusted to convict anyone. That's what happens when you try to smash together pieces of a puzzle that simply don't fit, she told the jury. Near the end of the trial, testimony emerged that Miller himself had told his wife, and at least one friend, that he believed the DNA evidence against him was strong enough to convict him and send him to prison. The case went to the jury on Friday, November 6, 2020. 7 women and 5 men deliberated that afternoon, then went home for the weekend without reaching a decision. On Monday morning, before deliberations resumed, Miller's wife called 911 from their home in Edmonds. Terence Miller had shot himself. He was 78 years old. The jury, still deliberating, was never told. That afternoon, unaware that the man they were judging was already dead, the jury returned a verdict: guilty of first-degree murder. What followed was, by the presiding judge's own description, close to unprecedented. Miller's defense attorney moved to dismiss the case entirely, arguing that a defendant's death before conviction should void the proceeding, and that there was no benefit to formally taking a verdict against a man who could no longer be sentenced, fined, or held accountable in any traditional sense. There would be frankly no public benefit in the court actually proceeding to take the verdict in this case, Martin argued, because you cannot sentence Mr. Miller. Deputy Prosecutor Craig Matheson disagreed just as forcefully. Miller, he pointed out, hadn't died of an illness or an accident. Mr. Miller did not die of a disease, or get COVID, or get hit by a car, Matheson argued. He had taken his own life, the prosecutor said, specifically so he wouldn't have to show up in court and face what the jury was about to decide. The Loomis family, Matheson argued, had waited 48 years for an answer. They deserved to have it entered into the official record, regardless of the timing of Miller's death. Superior Court Judge David Kurtz took weeks to consider the question before ruling. On December 17, 2020, in what should have been Miller's sentencing hearing, with no defendant present in the courtroom, Kurtz upheld the jury's guilty verdict. He called the situation truly an extraordinary situation and somewhat unprecedented, acknowledging that the case law both sides had cited didn't quite fit the circumstances in front of him. In the end, he sided with the prosecution. In lieu of a sentence that could never be carried out, the judge instead read and signed a document, formally affirming that Miller's guilt had been proven beyond a reasonable doubt. Labels and symbols are important, Kurtz said, and how this case is ended does matter. Jody's sister, Jana Loomis Smith, addressed the court before the ruling. Both of their parents, she said, had died decades earlier without ever learning who killed their daughter. She told the judge she wasn't seeking vengeance. She simply wanted the truth entered into the record that Terence Miller had murdered her sister. "We miss Jody's love, her sisterhood," she said, "and this pain is now part of our surviving life." Jody's brother, John Loomis, was 27 when his sister died and had already moved out to start his own family. He didn't attend the verdict in person. He watched it over a live stream instead. He got away with it for 48 years, he said afterward. Detective Jim Scharf, the same investigator who had spent years working the Van Cuylenborg and Cook case for the same department, had also carried Jody Loomis's file. "I'm glad that we got to hear the verdict," he said. "I think that was good for the family." Prosecutor Craig Matheson put it most plainly of all. "We got an answer," he told reporters. "Whether Mr. Miller was there or not, it does not diminish the verdict. There's something worth sitting with in that idea. Most of the cases on this list end with a name, a trial, and a sentence, or with a name and no chance for either. Jody Loomis's case is neither. It's the only one where the justice system had to decide, in real time, whether a conviction still counts if the person convicted chose, in his final act, to make sure he'd never have to hear it read aloud. The court decided that it does, not because it changed anything for Terence Miller. It didn't, but because a 48-year-old promised to a grieving family that someone would eventually answer for what happened to Jody still deserved to be kept, even if the person keeping it was gone before the jury foreman stood up to speak. It's also worth remembering what made this case findable at all. For nearly 5 decades, Terence Miller lived exactly where he'd always lived, worked the jobs he'd always worked, married, divorced, remarried, and eventually spent his weekends selling handmade pottery to neighbors a short drive from where he'd killed a 20-year-old woman on her way to see her horse. He never needed to hide, because for most of that time, there was nothing chasing him. The technology that finally caught up to him didn't exist yet when he committed the crime, and by the time it did exist, he had already spent decades convincing himself and everyone around him that he never would be. In the end, the very ordinariness he'd built his life around The same quiet, unremarkable existence that let him hide in plain sight for so long was exactly what a genetic genealogist needed to find him. A stable family, a documented lineage, relatives who had no idea their own curiosity about their ancestry would one day close the oldest murder file in the county. Snohomish County had now solved its two oldest cold cases within roughly a year of each other, both through the same emerging technology, both handled by many of the same people. Prosecutor Craig Matheson, who argued the Loomis case to its unusual conclusion, was the same prosecutor who had written the charging documents in the Van Cuylenborg and Cook case just a year before. Detective Jim Scharf, who worked both files, had gone from a department with two of the state's most stubborn unsolved murders to a department that had answered both of them inside of 18 months. But not every department that tried this new tool in those early years got a resolution this clean. In Colorado, investigators chasing a case nearly as old as Jody Loomis's would find that genetic genealogy could hand them a name just as easily as it had handed Snohomish County too. What it couldn't hand them, in that case, was a simple path to proving it. Because the man at the center of their investigation had spent his entire adult life under a name that wasn't the one he was born with. The detective who spent years leading this investigation would later admit there were entire stretches where she was convinced it was hopeless. There were definitely times during this, she said, where you felt, I am never going to figure this out. We are never going to figure this out. She was right about almost everything else in the case. She was wrong about that. On the morning of December 4th, 1975, 20-year-old Teree Becker hitchhiked to the Adams County Detention Center in Brighton, Colorado, to visit a boyfriend who was locked up there. She was, by her family's description, a free spirit, someone who lived life on her own terms and thought nothing of catching a ride from a stranger to get where she needed to go, a small kindness toward the world that the world did not return. Chandra Thurston, the criminalist who would eventually lead the case decades later, described her the same way. A young woman who lived on the edge, unafraid of a world that, in December 1975, still felt smaller and safer than it actually was. She left the jail sometime that day. What happened to her after that is still, in some ways, unknown. 2 days later, on the morning of December 6th, a couple riding motorcycles through a field near 100th Avenue and Lowell Boulevard in Westminster, Colorado, found her body. She had been sexually assaulted. Her clothing and personal belongings were scattered around her in the field, as if whoever left her there hadn't been in any particular hurry. An autopsy determined she died of asphyxiation. Whoever picked her up outside that jail, or wherever he found her next, had left almost nothing behind in the way of physical evidence anyone could act on at the time. No witnesses came forward, no vehicle description, no suspect. Investigators canvassed the area around the detention center and the field where she was found. But a woman who had hitchhiked to reach her destination in the first place left few leads to trace once she vanished. Just a young woman who had been trying to visit someone she loved and never came home. The case moved through the Westminster Police Department's files, the way so many others from that era did, reviewed periodically, reopened when a new detective inherited it, and quietly set aside again when nothing new turned up. Years passed without a single credible break, and the trail, such as it was, grew colder with each passing decade. The case sat that way for almost 3 decades, before technology gave investigators anything at all to work with. In 2003, the Colorado Bureau of Investigation managed to extract an unknown male DNA profile from evidence connected to the sexual assault. It was entered into CODIS, the National Criminal Database. Nothing matched. The profile, complete and specific, simply didn't correspond to anyone who had ever been arrested for a crime serious enough to require a sample. For 10 more years, that was where things stood. Then, in 2013, something unexpected happened. Not in Colorado, but nearly 700 miles away in Nevada. The Las Vegas Metropolitan Police Department submitted an unknown male DNA profile of its own into CODIS, connected to an unsolved 1991 case. A woman found raped and murdered inside her own apartment. Neither department had a suspect. Neither had any reason to think their case connected to anything happening a state away. The CODIS system flagged the match automatically, the kind of quiet algorithmic discovery that never makes headlines on its own, but occasionally rewrites the scope of an entire investigation. The 2 profiles were identical. It meant, all at once, that Teree Becker's killer hadn't stopped with her. He'd gone on, at some point in the 16 years between her murder and that 1991 assault, to kill again in another state, an unknown number of years, and quite possibly an unknown number of victims lost somewhere in between that neither department could account for, and neither had a name for him. For 5 more years, the connected cases sat exactly like that. 2 states, 2 murders, 1 confirmed shared killer, and no identity. Then, in 2018, investigators in both Westminster and Las Vegas decided the combined profile was strong enough to attempt something neither department had access to a decade earlier: investigative genetic genealogy. The Colorado Bureau of Investigation partnered with Parabon Nanolabs and a Denver-based genealogy firm called Solved by DNA to take the case as far as the science could carry it. It carried them further than almost any other case like it, but it took far longer to get there. In most investigations built this way, a genealogist can trace a family tree back through a handful of generations and find the living relative who fits every branch within weeks, sometimes days. This one took 5 years. The reason came down to one detail, buried in the suspect's own life story. He wasn't hiding behind a fake identity or an intentional deception. He was living, quite legally, under a name that genetics alone couldn't have predicted. His biological parents, Walter Graham Jr. and Nancy West, had divorced when he was young. His mother remarried a man named James Elliott, who formally adopted the boy and gave him his own surname. The DNA pointed unmistakably toward one family tree. The name attached to the modern-day branches of it, though, wasn't the name the suspect had been born with, and wasn't the name that decades of paperwork, associates, and public record had ever connected him to. To understand why that mattered so much, it helps to understand how genetic genealogy actually works. A genealogist doesn't search for a name directly. They search for genetic matches, distant cousins, sometimes 3rd or 4th cousins who share only a small fraction of DNA with the unknown suspect, and then build outward from those matches using marriage records, obituaries, census data, and public family trees, looking for the one living descendant who fits every branch. That method depends heavily on surnames lining up with biology. on the person at the center of the tree carrying a name that traces cleanly back through the paperwork genealogists rely on. Adoption breaks that assumption without breaking the biology underneath it. Thomas Elliott's genetic relatives were exactly where the DNA said they'd be. His legal identity, the name on his driver's license, his prison records, his obituary, simply lived one step removed from where the family tree pointed, and closing that one step took investigators 5 extra years. Investigators weren't just looking for a killer, in other words. They were looking for a man who had, without any intention of hiding, been legally renamed out of his own biological history before he ever committed the crime that would define his afterlife. By 2023, the genealogists had done it anyway. The name they arrived at was Thomas Martin Elliott, born December 14th, 1950. What investigators learned next explained a great deal about why a man capable of 2 separate rape murders had managed to stay invisible for nearly 5 decades. Elliott had spent, in the words of the Westminster Police Department, a large portion of his life in and out of the prison system. Shortly before he killed Teree Becker, he'd committed a burglary in Lakewood, Colorado, and was convicted, serving 6 years. While incarcerated, he was shuffled repeatedly through different facilities within the Colorado Department of Corrections, eventually being released from a prison in Las Vegas in 1981. He didn't stay free for long. Soon after his release that same year, he committed what police described only as a crime against a child, and received a 10-year sentence for it. He was released again, once more in Las Vegas, in 1991. Laid out this way, the pattern is difficult to look past. A rape murder in 1975, a burglary conviction shortly after, a crime against a child almost immediately upon release in 1981, a second rape murder within months of his final release in 1991. Elliott spent roughly 40 of his 40 years alive, either committing violent crimes or serving time for them, with only brief windows of freedom in between, each one apparently long enough for him to hurt someone new. Investigators have never determined whether he committed other assaults during the periods he was free that were never connected to him. Given the pattern, most who worked the case doubt Teree Becker and the Las Vegas victim were the only 2. That was the year he killed again, the same year the Las Vegas woman was found raped and murdered in her own apartment, the crime whose DNA would eventually connect back to Teree Becker 22 years later. This time, though, Elliott didn't get the chance to disappear back into the prison system. Not long after that second murder, on October 30th, 1991, for reasons investigators say remain unknown, Thomas Elliott took his own life. He was 40 years old. He had been dead for 27 years by the time a genealogist finally, quietly wrote his name down. Identifying him wasn't the final step. Investigators needed direct genetic confirmation, not just a genealogical inference, and Elliott had been buried in Nevada for decades. Exhumation isn't cheap, and it isn't always something a department's budget accounts for. A non-profit organization called the Vegas Justice League, which had previously helped fund cold case investigative work in the region, agreed to cover the cost. It's a detail that shows up more often than people expect in cases like this one. Police departments carrying dozens of unsolved files with limited lab budgets, increasingly leaning on outside advocacy groups and private donors just to take the next forensic step. Without that funding, Teree Becker's case might have had a name attached to it, in theory for years longer. with no way to confirm it beyond doubt. In October 2023, investigators recovered Elliott's remains from a Nevada cemetery and extracted a direct DNA sample from his bones. It matched the profile from Teree Becker's case. It matched the profile from the 1991 Las Vegas murder. Both cases, separated by 16 years, 2 states, and an unknown number of other crimes investigators may never fully account for, had the same answer. In February 2024, Westminster police announced what they'd found, closing a case that had outlived nearly everyone who first worked it. Chandra Thurston, the senior criminalist who had carried the case for years, described the moment plainly. "It was almost a huge relief," she said, "to finally say someone's name did this to Teree." Westminster Police Chief Norm Halbert framed the announcement in terms of the decades of collective effort it represented. "This case started in 1975, he said, "and to be able to close it today and represent all the men and women who have worked on this case is an enormous sense of pride and an enormous sense of accomplishment for the agency." Teree Becker's brother, David, her only surviving immediate family member, had waited nearly 50 years for a name. He'd since moved to Texas and had, by his own account, largely made peace with the idea that he might never get one. "I can't say enough how grateful I am," he said when investigators finally called. "It's hard to believe. After 45 years, the DNA can match and bring closure, which I'm grateful for." He was careful to credit the department specifically, not just the technology behind it. "I just really applaud the Westminster Police Department," he said. What mattered most to him, he added, wasn't punishment. Elliott had been gone for over 3 decades by the time anyone learned his name. There would never be a trial, a sentence, or a courtroom moment for David to witness. What mattered was simpler than that. Just knowing that that person is not out there taking away some other sibling's life, he said. "To me, there's comfort in that." It's worth pausing on how differently this case unfolded compared to almost everything else on this list. Most of the men identified through genetic genealogy in these stories, whether they lived to face a jury or had already died before anyone learned their name, were caught specifically because their family trees were ordinary and traceable, stable households, documented lineages, relatives who had no reason to hide anything about who they were related to. Thomas Elliott's family tree told the truth. Eventually, it just told it through the name of a stepfather who adopted a young boy, decades before that boy grew into a man capable of murdering at least 2 women in 2 different states. The adoption wasn't a cover story. Nobody was trying to hide Thomas Elliott's identity when James Elliott gave him his name, but it meant that the genetic breadcrumbs investigators needed to follow led, quite legitimately, somewhere other than where his biological father's name would have pointed, and untangling that took 5 years longer than cases where the family tree simply matched the surname on the birth certificate. There's a broader lesson in that delay, one that applies well beyond this single case. Genetic genealogy is often described, understandably, as a kind of forensic magic, a technology that can conjure a name out of a stray drop of DNA left behind decades earlier. It can, but the speed of that magic depends entirely on how tidily a person's biological history lines up with their legal one. Divorce, adoption, name changes, closed records, any of the ordinary complications that reshape a family without any intent to deceive anyone can just as easily stall an investigation for years. Thomas Elliott wasn't cunning. He was, in the most literal sense, just a man with two names, and the 5 years it took to connect them cost two families that much additional time not knowing. Westminster's cold case unit didn't stop there. At the time of the announcement, the department said it was carrying 10 other unsolved cases and credited the Becker breakthrough with giving investigators, in Thurston's words, new vigor and new direction for tackling them. Every one of those remaining 10 files represents a family somewhere still waiting the way David Becker waited, without knowing whether their case will resolve in 5 years, 15, or never. The Becker case offered no guarantee about timing. What it offered was proof that even the most tangled family tree eventually yields, given enough patience and enough funding to see the DNA all the way through to a name somewhere in that list, in Westminster or in departments like it across the country. Another family is still waiting on a family tree nobody's finished building yet. 2 states, 1 shared killer, and a name that took 5 years longer to find than it should have, simply because of how ordinary his life had actually been. It's a reminder that runs through nearly every case in this episode. The technology is only ever as fast as the paper trail underneath it. Sometimes that trail is straightforward, and a family tree collapses to one name within hours. Sometimes it winds through a courthouse adoption record from decades earlier and costs investigators years they can never give back to the families waiting on the other end. The next case on this list moves in almost the opposite direction. A killer identified in less than a year, not primarily through a family tree at all, but through a technology that tried to draw his face directly from his own DNA, long before anyone even attempted to search for his relatives. Detective Mike Fields put it plainly, years after the fact. Despite hundreds of hours of investigation, close to 100 DNA samples, and interviews with hundreds of people who knew her, Christine Franke's killer still walked free, keeping his secret safe. He would keep it for 17 years. It would take 2 entirely separate DNA technologies, one of them a total failure, and one of them a genuine breakthrough, to finally take it away from him. On the morning of October 21st, 2001, 25-year-old Christine Franke had just finished a double shift at Cigars, a restaurant at Universal Studios Orlando, where she worked to help pay her way through the University of Central Florida. Christine had grown up mostly in Vero Beach, Florida, after her parents moved the family there from New York when she was about 9 years old. By all accounts, a free-spirited young woman who liked living life on her own terms, she'd enrolled at UCF to pursue a degree in education and was just 2 months from graduating. The demands of school, work, and daily life in Orlando meant she didn't get back to Vero Beach to see her family as often as she wanted to, something that would only sharpen the grief that followed. She was 2 months from graduating with a degree in education. She'd made around $300 in tips that morning. Her roommate was out of town. When the roommate couldn't reach her by phone later that day, she asked a neighbor to check on her. The neighbor found Christine dead inside their Audubon Park apartment, lying face down and partially undressed, with a single gunshot wound to the head. Investigators found a substance on her body that appeared to be semen, despite no other evidence of sexual assault, along with clear signs that roughly $300 in cash had been taken from her purse. It was, on its surface, a robbery that had gone catastrophically, inexplicably far. Over the following months, Orlando police interviewed hundreds of people connected to Christine's life. Friends, co-workers, acquaintances from the restaurant, and from campus. They collected close to 100 DNA samples from potential suspects and ran the profile recovered from the scene against CODIS, the National Criminal Database. None of it produced a match. Whoever had killed Christine Franke had never been arrested for anything serious enough to leave his DNA on file anywhere, and he apparently wasn't anyone in her immediate orbit either. Detective Fields, who would eventually inherit the file years later, described the years that followed in blunt terms. Despite everything investigators tried, Christine's killer simply walked free, keeping his secret. The case went cold and stayed there for 15 years. In October 2016, Orlando police tried something new. Using a National Institute of Justice grant, they sent the crime scene DNA to Parabon Nanolabs for its snapshot phenotyping service, the same kind of forensic prediction that would later be tried in several of the cases on this list. Parabon scientists analyzed the genetic sample and produced a composite, a computer-generated prediction of the suspect's likely appearance. An African-American male between 25 and 40 years old, with black hair and brown eyes. Orlando police released the image publicly, hoping someone would recognize it. Nobody did. The composite generated no meaningful leads at all. It's worth pausing on that outcome, because phenotyping doesn't always work this way. Genetic predictions of eye color and hair color rest on fairly well-established science. Broader facial structure and other features are far less certain, shaped as much by environment as by genetics, and several critics, including civil liberties researchers, would later point out that phenotyping composites can be specific-looking without being especially accurate, confident enough to seem like real evidence while carrying a wide margin for error underneath. In Christine Franke's case, the composite simply sat there for 2 years, a face that may or may not have resembled her killer, generating nothing, while the actual answer waited quietly in a genealogy database nobody had thought to search yet. The case might have stayed exactly there if not for what happened a state away, in California, 18 months later. In April 2018, investigators in California announced the arrest of Joseph James DeAngelo, the suspected Golden State Killer, identified through a genetic genealogy technique nobody outside a small community of hobbyists and forensic specialists had ever heard of. Detective Fields later said that arrest was the moment he realized the same approach might finally crack the Franke case. Exactly 2 weeks after DeAngelo's arrest, Orlando police received an email from Parabon Nanolabs. The crime scene DNA, run against the public genealogy database GEDmatch, had produced promising matches. Genetic genealogist C.C. Moore, the same specialist working several of the other cases on this list that same year, took on the Franke investigation. She would later call it the longest genetic genealogy case she'd ever worked, specifically because of how large and difficult to untangle the suspect's family tree turned out to be. GEDmatch returned a list of roughly 1,500 people with DNA profiles bearing some similarity to the unknown suspects, an unusually large pool that reflected just how many branches the true family tree actually had. Moore had to narrow that list down branch by branch, cross-referencing distant genetic relationships against public records, marriage licenses, and family trees other genealogy hobbyists had built and shared online. looking for the family structure that could account for every match at once. It was, by her own account, slower and more painstaking than almost any other case genetic genealogy had cracked up to that point. 2 names eventually rose to the top: a man named John Hogan, living in Valdosta, Georgia, and a woman named Jackie Faison, living in Virginia. Neither of them had any idea their DNA was being used this way. Hogan had submitted his own sample to Ancestry DNA years earlier, hoping to learn more about his family history, including whether any of his ancestors had been enslaved. He later uploaded the results to Gedmatch out of simple curiosity. He'd never heard of Christine Franke. He didn't recall ever meeting the man his DNA was about to help identify. "We have a huge family," he said later. "I've got like 650 fourth cousins and a bunch of second and third cousins." Investigators traced Hogan and Faison back to a shared ancestral couple, Charlie and Mary Bergman, and worked forward from there through the branches of their descendants. That work led to Eleanor Holmes, a 79-year-old woman living in Valdosta, Georgia. In late October 2018, investigators collected a DNA sample from her and determined that the crime scene profile was consistent with being her biological child. Eleanor Holmes had 2 sons, Reginald and Benjamin, both living in Orlando. Detectives tracked down Reginald first and eliminated him as a suspect once his DNA didn't match. That left one name: Benjamin Lee Holmes Jr., a manager at a local Wendy's restaurant, living an otherwise unremarkable life, just a short drive from where Christine had died 17 years earlier. Investigators still needed his DNA directly, and still needed to get it without tipping him off. A judge issued a warrant, allowing police to track Holmes's cell phone, and detectives used the data to locate him at a friend's house on Lighthouse Road in Orlando. On October 30th, 2018, an undercover detective watched Holmes drink a beer and smoke a cigar in the driveway. Once Holmes went back inside, another detective collected 7 discarded cigar butts from the public sidewalk area nearby. The lab results came back fast. The DNA on the cigars matched the crime scene sample. 3 days later, on November 2nd, 2018, detectives arrived at Holmes's door with a warrant for his arrest and a warrant to collect his DNA directly. Holmes told them he had never met Christine Franke, had never been to her apartment, and knew nothing about her murder. When Detective Fields showed him the search warrant for a direct swab, Holmes, according to police records, became instantly nervous. Asked how his DNA had ended up at the scene of a murder he claimed no knowledge of, Holmes suggested it must have been planted, or that the science was simply wrong. It wasn't. The formal swab confirmed what the cigar butts already had, closing a loop that had been open for 17 years. At a press conference announcing the arrest, Christine's mother, Tina Franke, could barely believe what she was hearing. "I honestly never thought they would find him," she said. "They had DNA all along, and just nobody ever matched up. I thought, possibly he would be dead. How can you live 17 years under the radar?" She said she was overwhelmingly grateful to investigators who, in her words, never gave up on her daughter's case. Holmes pleaded not guilty and would remain free on bond, and later in custody awaiting trial, for 4 more years while the case moved through Florida's legal system. His attorney spent much of that time trying, unsuccessfully, to keep the DNA evidence away from a jury entirely, arguing at one point that Holmes's mother had been misled into giving her own DNA sample, told only that investigators needed it to help identify a murder victim rather than to build a family tree pointing at her son. That challenge failed, and the case finally reached trial in early 2023, 22 years after Christine's murder. When the trial began, his attorney didn't dispute that his client's DNA had been found on her body. Instead, the defense argued someone else had staged the scene entirely, planting Holmes's biological evidence deliberately to frame him, though the attorney never offered an explanation for how anyone could have obtained that evidence in the first place. There is not one single other piece of physical evidence that links Mr. Holmes to this crime, his lawyer told the jury in closing arguments, noting the absence of fingerprints, hair, shoe prints, or any other trace connecting Holmes to the apartment. Prosecutors, for their part, acknowledged they couldn't fully explain how Holmes and Christine had crossed paths in the first place. What they had was the DNA, collected from her body in 2001 and matched conclusively, twice over, to Holmes 17 years later. On February 7, 2023, a jury convicted Benjamin Holmes of first-degree murder. Christine's family posted their reaction shortly after the verdict was read. "Guilty is the word we've been waiting to hear for 22 years, they wrote. Today, a jury delivered a verdict, and justice for Chrissy was served. Because first-degree murder carries an automatic life sentence under Florida law, the outcome of Holmes's punishment was never in doubt. The formal sentencing hearing took place the following month. On March 23, 2023, Holmes addressed the court directly before the judge handed down his sentence. "I am not the man or the person who murdered Christine Franke," he said. "It hurts. Unfortunately, I'm the man who was found guilty." The judge sentenced him to life in prison without the possibility of parole, and advised him he had 30 days to file an appeal. Tina Franke, seated in the courtroom, said she was surprised Holmes had chosen to speak, and firmly rejected the suggestion embedded in his statement. "If someone's accused wrong, I would never want that to happen," she said. "But the evidence all just points to him. We've waited 22 years for this. There's a strange symmetry sitting underneath this case that's easy to miss on first read. Two entirely different genetic technologies were tried here, years apart, and only one of them worked. The 2016 phenotyping composite, built to predict a stranger's face directly from his DNA, generated a plausible-looking sketch and absolutely nothing else. A demonstration of exactly how far that particular science still had to go. The 2018 genealogy search, built instead on the ordinary, unremarkable fact that nearly everyone has relatives who've been curious enough about their own ancestry to spit into a tube, found him within months. One method tried to reconstruct a stranger from scratch. The other simply followed the people who already, unknowingly, held the answer inside their own family trees. People like John Hogan, who had never heard of Christine Franke, and who said afterward that he stood behind her family completely. "We're grieving with you," he told them. "At the same time, we're happy, and we are so joyous that you found closure. It's worth sitting, for a moment, with what people like Hogan and Jackie Faison actually did here. Neither of them committed a crime. Neither of them knew Benjamin Holmes well, if at all. Hogan couldn't even recall meeting his own second cousin at a family reunion. They uploaded their DNA to a free genealogy website because they were curious about where their families came from, the same reason millions of people do it every year. And because of that ordinary curiosity, a family tree quietly existed online that a detective and a genealogist could eventually walk through, branch by branch, until it led to a locked door in Orlando. Neither Hogan nor Faison ever agreed to help solve a murder. They just happened to be exactly the kind of distant, documented relative genetic genealogy depends on. That's the through line connecting every case in this episode, whether it ended in a life sentence, a name attached to a man already dead, or a wrongful conviction finally undone decades too late. None of these cases were solved because a killer made a careless mistake at the scene, and none of them were solved because a detective got lucky. They were solved because ordinary people, completely unconnected to any crime, decided out of simple curiosity to learn a little more about where they came from. Ancestry became, almost by accident, one of the most powerful investigative tools ever built. Not because anyone designed it that way, but because it turns out that nearly every family tree, given enough patience and the right forensic partner, eventually leads somewhere. Christine Franke waited 22 years for her family to hear a jury say the word guilty. Tanya van Cuylenborg and Jay Cook's families waited 31, through a conviction, an appeal, and a reinstatement. Pam Felkins' family got a name, with no one left alive to answer for it. 4 men in Austin got their own names back, at a cost none of them should have had to pay in the first place, one of them too late to hear it himself. Jody Loomis's family got a verdict, read to an empty defendant's chair. Teree Becker's family waited nearly 50 years for an answer that arrived 5 years later than it should have, because of an adoption that had nothing to do with the crime itself. 6 different endings. 6 different families who spent decades not knowing. One technology, built from nothing more exotic than curiosity about where we all come from, quietly rewriting what cold case means for departments and families everywhere, still waiting on their own answer. If tonight's cases showed how a family tree can finally close a decades-old file, our next investigation turns to something almost the opposite. Cases where investigators know exactly who they're looking for and still can't find them. Men who have spent years, sometimes decades, hiding in plain sight from the people looking hardest for them. Some of them are still out there tonight, closer than anyone would like to think.